My name is Marina. I'm a licensed attorney here in Moscow. I work in a human rights center memorial, and therefore I deal a lot with suing the state or being sued by the state. Therefore, administrative justice is something that became an integral part of my life. Administrative justice in Russia is very young, and therefore we wanted to seize this moment and reflect upon some issues that Russian administrative justice is currently struggling with. The first issue is limitation on the right to introduce new evidence in the court when this evidence were not disclosed during administrative proceedings. Some people believe that this is an infringement, a violation on the right to effectively participate in the trial. So today, we will try to understand whether these limit, if at all. The second issue for today's discussion is the court's refusal to review interim decisions of the governmental authorities, like, for instance, the decision to initiate an inspection. Some people believe that by challenging the decision to initiate an inspection, they can do the justice at the very early stage. However, the courts refuse to review these decisions until the inspection is over. And in today's webinar, we would like to use comparative analysis to evaluate these two Russian trends. We don't have an ambitious role to give the one and the only right answer, but we do hope to advance the discussion. As you have probably noticed from the title, this is the second part of the webinar. The first one was done about American experience with administrative justice. We've learned that in the US, there are a lot of governmental agencies that actually have their own dispute resolution bodies, and there are administrative judges that are in these bodies. So essentially, the administrative judges are employed by the agencies, but at the same time, they are independent. For a lot of Russians, that would seem like something unspeakable, because we would think that these judges, because they are employed by the governmental agency, these judges are not independent. They are sort of pocket judges. But the American experience shows that this can work. And in fact, the decisions of administrative judges can be appealed to federal courts, and federal courts in America enjoy a lot of independence and public trust. So by knowing that there is a very small amount of decisions taken by the administrative law judges that were revoked, quashed by the federal courts, we understand that the quality of these decisions is very high. So today we are focusing on other two countries, Russia and the Netherlands. And we want to discuss two particular issues: introduction of new evidence and the review of interim decisions. And now I move to introducing our guests. So today here we have Anatoly Simonov, who is intellectual property representative of Russian Presidential Commission for Entrepreneurs' Rights. Welcome, Anatoly. It's great to have you here. Then we have Dr. Wim Timmermans from the Netherlands. He is an attorney. He's a partner in the law firm Timmermans and Simmons International Business Lawyers. He's also an arbitrator basically all around the world, and including Moscow, in Mkaz.
Hi.
Welcome,
Hi.
Wim.
Welcome.
The third guest is Thomas Hoyer. He is a retired American administrative law judge at the Environmental Protection Agency. Welcome, Tom.
Good morning.
And we also have here Jeffrey Bird, who is a retired partner at the US firm Arnold and Porter. Hello, Jeff.
Good to be here. Thank you.
And we finally have Denis Karimov, who is a chief legal officer for administrative law at law firm of Grupa Forma. Welcome, Denis, and thank you actually for organizing this webinar, because it's thanks to you that we are having this discussion. I would also like to note that we have here below the links to the presentation for today, as well as some supporting materials with the introduction of the American legal system, the American administrative law system. So those who are interested can go and look up these presentations. These presentations are also available at our discussion pages in Facebook groups. So those of you who want to see them, please follow the links and enjoy. So without further ado, let's start our discussion. And the first the first guest that I'd like to invite for the presentation is Wim. So Wim Timmermans, I am giving the floor to you.
Okay, thank you. Thanks a lot. Okay, well, thank you all in the first place for granting me this opportunity to talk a bit on the Dutch system of administrative law. Well, it's a very nice and pleasant task to do that for hopefully a broad public. Well, as already pointed out, I'm going to highlight a bit the basics of the administrative law system in the Netherlands, and the purpose of this presentation is to provide a brief outline of Dutch administrative law, and in particular to discuss the principles behind Dutch administrative law. I will also provide you with a bit of the background how was this administrative law achieved, and how did it grow during the last decennia. And finally, I will also provide the audience with a brief overview of administrative procedure in the Netherlands. But to start with the brief outline, it's a relatively new law which we have. It is called in Dutch the Algemene Wet Bestuursrecht, which translates it more or less into the general law or the general bill on administrative law. And the purpose of this new law, which entered into force in 1994, was basically to group together all the principles and all provisions which were spread over different administrative law, and so that all the principles and all the basic provisions were collected in one kind of uniform law. And well, the purpose of that was basically that there were many contradictions between the laws. Different terms were used, and different periods of time. Well, periods to challenge an administrative decision and things like that. They were all different and are now uniform, have been uniformed. So that is basically the first reason for setting up this new law. It has been expanded in the during the 30 years it's now in force, and the latest novelty introduction of a new chapter, which allowed the possibility to settle administrative disputes not by a court procedure but by mediation, by way of mediation, and that's already quite successful. If a court thinks that this kind of dispute could better be settled by mediation, the court will refer the dispute to a mediator, and a mediator is going to try to find a solution for the problem. So that is basically a major novelty. To talk a bit more about fundamentals, the basic basic goal of the law is to provide citizens with protection from the state, and that is something you will have to keep in mind because the law is full of different provisions offering that protection. A second goal is to what I already explained as one of the reasons for the new law, that a certain kind of uniformity was provided for, and also systematization and simplification. Also, certain principles and certain concepts that were not in previous laws, but have been developed in a court practice, have been included now in the 1994 law. So that is basically a bit about the background of the Dutch law on administrative law. The structure of the law is also rather transparent. Chapter 1 starts with giving the definitions of a number of fundamental concepts of the administrative law. It provides for certain rules on the relationship and the interaction between government bodies and citizens. It also provides for general provisions on decisions, and I come back to this concept of decisions later on, and there are also specific provisions on the decisions, and that deals in particular with in Dutch administrative law, distinction is made between decisions, besluiten in Dutch. For those who know German, the Dutch word besluit is the same as the German Beschluss. Besluiten of a general nature, and we have also besluiten of a non-general nature, i.e. Decisions which envisage application in specific individual cases. So that is a main difference, and which should be kept in mind for the remainder of my presentation. So that is well, and there are provisions also on the procedure if you want to challenge a decision of a government body. Then well, the law sets out the whole procedure for that. So that is basically the structure of this new law. Um, well, some basics further, and I come back to the besluit. So we have three. Well, if you deal with administrative procedures in the Netherlands, the key word is that there are three B's which are vital for seeing if a decision can be challenged. It has to be a beslissing thing. So a B. That's the first B. It has to be a besluit, and in particular a besluit of a non-general nature. Then this decision, this besluit, has to be taken by what we call a bestuursorgaan, an administrative body, and it can be challenged by a person who is directly affected by the decision. So it has to be directly, not indirectly. And I already tried to give a rather common example. If the municipal body in the city where I'm living, Leiden, takes a decision to fell a tree in my street, I can file a complaint against it, because this is a decision of a non-general nature. It's well, one specific a tree in front of my window, and it is a decision taken by an administrative body, bestuursorgaan, by which my interest is directly involved, because well, the tree is taking the sun away, so that the sun is not directly shining in my room, and well, I like to have a nice look at this tree. So there is a fat chance that a court will cancel this decision. But if the same municipality decides to fell trees in the next street, well, in that case, what would be my direct interest in that, other than that I like to walk through the neighborhood and enjoy the nice trees here, but I'm not directly affected by that decision. So in that case, there is a fair chance that the court will not accept my challenge. So that is a brief example to explain a bit this concept of the three B's in Dutch administrative law. Of course, reality in real life, well, much more complicated and complex matters and decisions are being challenged, and decided in court. But just to give you an idea of how the Dutch system works. So that is then well it is not so that every decision of every administrative body can be challenged. For instance, well, the courts and a number of other administrative bodies or government body, these shall not be considered that administrative bodies in the meaning of the law. So the law itself gives a long list of all these administrative bodies that shall not be subject to the law. Furthermore, the law gives some prescriptions for administrative body, these how to take a decision, the procedure in which the decisions must be taken. They must, and that is written in Article 2 of the law, they must perform their task in an unbiased way and without any prejudice. And also they must see to it that those persons who are involved in the preparation of the decision shall not have a personal interest in the taking of the decision. So if it appears during the preparation of the decision that certain civil servants have a personal interest in the decision, they well the body must then see to it that they are no longer involved in the process. Now something about the procedure. We how to challenge a decision of an administrative body. The first stage is the what we call the so-called bezwaar. Well, that's the more or less the complaint procedure. If you don't agree with a decision, you may try to challenge that with the same body that took the decision. And you must do so within a period of 6 weeks after the decision was taken. So in fact, you file a complaint and you list the grounds for not be in agreement with the decision. And well, in practice, well, in most cases, I would say between 85 and 90% of the cases, complaints are rejected. So well, and that led to the conviction amongst many lawyers that this is not a necessary step, and it would be more fair to go directly to court. But it has been point taken, Marina. It has been well, it's included in the law, just more or less to create a first obstacle, so to say. A first step to make it a bit difficult for citizens and to prevent a load of complaints with the administrative body. Okay, so we well, and then if the complaint is not well is rejected, the next step is to go to court. For that, for challenging the decision in court, there shall apply another period of 6 weeks. And well, it's a rather simple procedure. The costs are rather low. The court fees are rather low, and there is not a requirement to engage a professional lawyer. So in principle, citizens can go in person to the court and challenge all kinds of decisions. Courts, by their very nature, well, they will rather thoroughly investigate the case, and then within in principle within two months after the last court hearing, the court shall take a decision. So well, if again this decision is negative for the appellant, then in that case you can file you can start proceedings before the Supreme Court. As I pointed out in my slides, there are different courts for that, and that depends on the nature of the dispute. Well, I think that the last thing I want to stress is that grounds for courts to quash a decision are, well, in many cases, general principles of law, and they are called in Dutch algemene beginselen van behoorlijk bestuur, which more or less translates with general principles of good governance. And this has been developed in court practice, and they include such principles as well, contradiction with a general binding rule of law, prohibition of détournement de pouvoir. That's a French term which translates with, well, you cannot use a power to a goal other than that it was provided for. So that is basically what I would like to say in this first instance. Thank you for your attention.
Thank you, Wim, for great presentation. I did have some questions for you, but I don't think that we have the time for them. So in case we have the time further on, I'll go to these questions.
Yeah.
And now I'd like to yield the floor to Denis, who will give his overview about the Russian system. Denis, please.
Thank you, Marina. Dear friends, please follow to my presentation, available in the right corner of this window. And first, I just want to say that we can challenge decisions of administrative authorities in accordance with 3 laws. If you are a legal entity or an individual entrepreneur, and the decision of non-general issue, of non-general nature taken an administrative authority affects of business, you will use the Commercial Procedural Code of the Russian Federation. This code stipulates how to resolve economic disputes. If there is no economic dispute and you challenge of an administrative body decision that hold you to administrative offense, you will use the Code of Administrative Offenses. This is the second law. But however, if you challenge the decision to hold a person liable, but it involves business, you will still use the Commercial Procedural Code. In other cases, you will use the Code of Administrative Justice. It looks like, formally speaking, the criteria for challenging administrative decisions, and that criteria are similar to those described by WIM. However, the judicial practice has developed additional criteria, especially on the issues we are discussing here. These differences are based on Russian history and 2 reasons. On the one hand, we have distrust of private person, sometimes mutual, to activities of the public administration. On the other hand, the public administration position that, for example, state control cannot be considered effective if it does not find violations. The fines are good for the state budget too. In addition, the public authorities fear to admit that the state is not right. As a result, legal entities and individual entrepreneurs do not want to disclose evidence in the administrative proceedings. They think it is better to introduce new evidence before court to prevent the authority from making advantage from it. State bodies are not angels too, of course. During administrative proceedings, they don't want to consider evidence that prove that there is no fault on the side of a person. The both legal entity or an individual entrepreneur or other private person. Legal entities and individual entrepreneurs want to appeal any interim acts that are taken during administrative proceedings, and not to wait when an authority adopts its final decision. They explain that they want to prevent illegal activities of the public administration immediately. So, in Russian practice, we need to find a balance that has been searched for a very long time. I want to mention the main historic dates. In 2002, my teacher, the head of the Administrative Law Subdivision of the Ural State Law Academy, Professor Sergei Khazanov, proposed to the scientific community how to solve this problem. He suggested that relations with the public administrations should determine the balance of mutual interests. At the same time, it is necessary to ensure, he states, that private persons can effectively defend themselves from public administration, and the public administration is not deprived of the opportunity to effectively perform its functions. That is why, for example, you cannot challenge orders to initiate inspections. You need to wait until administrative proceedings finishes. Then you will have the right to challenge procedural deficiencies during the inspections. However, during administrative proceeding, the public administration may adopt other decisions. For example, it may order the person to disclose documents and other information and punish for a failure to do it. Do I need to wait until administrative proceedings finalize? No, I don't, because in 2009, the Constitutional Court of the Russian Federation considered unconstitutional refusals to review interim. Not all, of course. Interim measures make sure that a person does not escape consideration of a case imposing a fine or other administrative proceeding offenses. For example, they are administrative detention, personal examination, inspection of the transport vehicle, and so on. These measures were established by the Code of Administrative Offenses. The Constitutional Court has decided that the consequences that these measures create are so significant, so it is impossible to postpone. It is impossible to postpone that appeal, their appeal. Unfortunately, unified ideas about the balance has not been worked out yet. For example, in 2016, the Supreme Court of the Russian Federation permitted challenging a decision to initiate an inspection conducted by the Federal Antitrust Service. However, the same orders that are adopted by other agencies still cannot be appealed immediately. There is a clear trend on the restriction to introduce new evidence too. The need for restriction was lobbied by the Federal Customs Service in the beginning of 2000. It claims that when it examines cases of violation of legislation controlled by it, private parties intentionally withhold some of the evidence and then bring them to court, challenging the outcome of the examination. As a result, the service says the court has to recognize the decision of the Federal Customs Service as illegal. But of course, we're still struggling to find a balance. For example, in 2011, an option was discussed that allowed courts to admit new evidence at their own discretion. In the future, this option was established for the Federal Customs Service. In other cases, when challenging acts of other administrative agencies that are challenged, for example, according to the rules of Code of Administrative Justice, you will not be able to present new evidence. That's why Marina and I decided to conduct a webinar to find out what practice exists in other countries, as well as how our practice is democratic. I mean, our Russian, of course, practice. And finishing, I would like to share my thoughts on these subjects. The limitation that we have in Russia are part of our legal tradition, to my mind, which has historic rules. In this regard, I advocate the approach according to which the balance is reached only if the court does not substitute the administrative authority in the administration of justice. And this is possible only if the court does not accept and evaluate evidence that has not been disclosed by either a person or an administrative body during administrative proceeding. If the administrative body does not evaluate the evidence duly submitted by a party during administrative proceeding, and this failure affects the legality of the act, the court must annul that decision without even examining them for the administrative body. With regards to the evaluation of interim decisions, I believe that only those decisions that entail significant legal consequences for a party should be challenged in courts before the administrative proceedings are finalized. In my opinion, such a compromise will lead to certainty in the relationship with the authorities and therefore will protect effectively the rights of parties involved. And my last sentence I do like to say, I want to say that in addition, traditionally in Russia, the executive branch claims to be central to the system of separation of powers. In this regard, the absence of clear criteria for judicial control over the public administration has led to the emergence of the infamous principle of there is no reason to distrust the public administration. It allows the court to be more loyal to the arguments presented by the authority, unfortunately. I believe that what I suggest can limit such loyalty by creating a rigid standard that takes into account Russian views on justice. In this connection, they are not a limitation of the powers of the court, but a way to take into account the Russian realities. So, thank you for this attention, and I do, Marina, where I want to answer your questions if you have.
Well, thank you, Denis, for the presentation. We have 1 minute to discuss the following thing that I have for you. So you mentioned that the parties are afraid to disclose the evidence during the administrative proceedings because they think that the governmental authority might abuse them or use this information somehow, not in their favor. So I'm wondering, what's your opinion and how should we tackle this fear? Thank you.
Thank you, Marina. I tried to answer very briefly. We have in our administrative law doctrine the principle of ensuring the trust to the public administration. This principle was stipulated by the Constitutional Court of the Russian Federation, and it means if you have any evidence and if the authority ignores this evidence, the court will react and will annul that evidence or to enforce the authority to consider this evidence once more. That is all.
Denis, for your answer. And now we yield the floor to Anatoly Semenov, who will share his thoughts and ideas about the Russian administrative law and how it should evolve.
Marina, thank you. I'm not sure if you hear me. It's okay? Everything is okay. Fine. First of all, I would like to say that I'm very glad to see all of you, and I'll try to explain why do I exist and our Institute of Ombudsmen for Protection of Entrepreneurs' Rights has appeared in the Russian Federation. All those problems that were mentioned by Denis were one of the reasons for our appearance in our legislation, because we really have a lot of problems in administrative practices and in court practices as well. And because of different approach to the legal system of the different society levels, I mean, for example, entrepreneurs are limited to access to, for example, judges. You cannot become a judge if you are not the assistant of the judge. Or, for example, some other people who are not from the governmental positions, they also cannot have access, the equal access, I mean, to the powers of executive power, of legislation power, and court power. It's very important to understand. And it happens so that each kind of social strata has different access to the powers. So that is why the ombudsman, like executive power, has appeared. In order to try to make equal possibilities for the entrepreneurs and, for example, some state bodies in the court. So we are acting like prosecutors, special kind of prosecutors who are playing on the side of the entrepreneur. So all the problems that were mentioned by Denis really exist. The first problem for me, at least as a person frequently coming to the courts, is that you can lie in our courts. So each party of the dispute can lie, and there is no penalty for this. It is ridiculous to imagine in the United States, I understand this, but in Russia this is so. So this is the first problem. The second problem is that you don't have the disclosure procedure, like you know it in the United States, for example. We really do not have the obligation to discover all the evidences before the court begin to consider the case on the matters. And this is the second terrible problem, because you never know which set of evidences will be presented to the court, and which kind of which evidence will be distrusted by the court, which evidence you need to disapprove, or you are acting in the court in the total, you know, vagueness. You don't know what to, what evidences you need to say against. So what you need to say as the legal argument or as a factual argument. And this main problem creates the all other problems that were mentioned by Denis, because all these games and gambling with the evidences are coming from this problem. So you can lie and you can choose which evidence to bring to the court. And that is why all these questions appears. By my opinion, in Russia, all the state bodies, I mean executive bodies who are trying to make the administrative procedures, they usually have the right to pursue to discover the evidence. So that makes them much more powerful in gathering what do they need to prove their position in the court. And that is why it is frequently comes to the situation that the civil entity just cannot provide something against that, because the civil entity do not have special powers to enforce the disclosure. And that is why I just want to stress my short view on this problem, that in the current position that happens in our courts and administrative procedure, we need to provide some additional help to the civil entity or commercial entity to provide evidences even in the court, even after the administrative procedure, because usually they just cannot enforce the disclosure or the evidences that is held by the administrative body. So this is main aspect that I wanted to stress. Thank you, Marina.
Thank you, Anatoly, for this very short introduction and short presentation. Short and succinct and clear. Thank you very much. I do have questions to you about these two issues that we are discussing today, namely, what are your opinion, personal, and your opinion as the representative of the Ombudsman on introduction of new evidence. So what's your idea on that, and what's your idea about the refusal of the courts to review interim measures?
Well, interim measures are really sometimes dangerous for the civil entities because sometimes they are connected with some, for example, arrest or with some limitations that severely affect the possibilities of the civil entity to perform. So such kind of, for example, blocking of the content in the internet. Recently, I had some cases about that when our administrative body, Roskomnadzor, introduces some order to block some internet site, which is, for example, showing some movies or trading with some goods. But sometimes this interim, this is not final, but interim order, in fact, leads to total stop of the business. So the entity just cannot function because the website is blocked and that's it. So you don't need even to wait for the decision on the matters because you already achieved the goal just with your interim decision. So naturally it is necessary to have the procedures to overcome, to appeal and to introduce new evidences that can support your position, because such interim measures are frequently very fast. You cannot have a long administrative full-scale procedure, for several months to pursue the court to consider all the evidences. This is preliminary, measures to block. They work in 2 or 3 days, so that's it. I think that's main procedure, main question that I can say about interim measures. That's it.
Thank you, Anatoly. And now there is the time for our American guests who used to be the main speakers for our previous part. Jeff and Tom, if you have the comments or if you have questions, this is your time right now to voice them.
Tom, do you have any?
Mediation. 2 questions. Mr. Timmerman, in America, mediation is increasingly being used to resolve administrative disputes for the reason that the number of these disputes has grown so large that the administrative tribunals can no longer handle them through formal adjudications. So they have to resolve many through the faster, less formal procedure of mediation. Question, is that the reason for the use of mediation in the Netherlands? And if it is this a healthy development? Second question, for the Russian panelists. I was told, this is over a decade ago, that mediation is less used, much less used in Russia than in America, for one reason, because Russian legislation lacks any provision to protect the confidentiality of mediation negotiations. Whether or not you know whether this legislative situation still obtains, what is your view of the widespread of how widely used mediation is now employed in Russia, and would you think its greater use would be a healthy development?
Is the question for me?
One question for Mr.
Follow
Timmerman and one for the Russian panelists about the use of mediation in Russia.
Okay, so,
Okay, so we will.
Wim should start, I think.
Yes, I shall start first. Well, brief answer to that. Well, there are different reasons. The first of which is more or less the same. More or less the same as in the United States. The workload of the courts is rather big. So if they can transfer a part of the workload to mediation, that the courts will definitely do that. But the nature of the cases must be fit for mediation, and that is something for the courts to decide. The second reason is that that mediation is thought to be much cheaper. It's cheaper. It's less expensive than court proceedings. So that's the economic reason, and the third reason in my view is to give a certain service to the citizens, to delegalize, if that is a verb in English, the dispute, and to make it more acceptable for the citizens to go through mediation rather than through a court proceeding. Yeah, does that answer your question?
In Russia.
Okay, about the Russian experience, I was thinking maybe Anatoly would like to handle this question.
Sure. Actually, the ombudsman is some kind of mediation procedure as well. So when somebody from entrepreneurs comes to us, we already are in some kind of mediation procedure, because we have some powers to pursue the administrative body to cancel their orders, for example, without courts. So we can just stress our legal position to them, and they sometimes agree, sometimes not, but still it sometimes lead to relaxation of the problem. But if you are talking about the confidentiality, actually I don't see much problem in Russian courts with confidentiality, because if you really need to limit the public access to the court procedure, you can ask court to come to the closed hearing, so-called. So we also have such procedure in Russia, and if you need to hide some details that are personally sensible, you can just ask court to come to the closed procedure. That's it. So it is not the reason for mediation. Mediation in Russia is not so popular because the legal procedures are very cheap in Russia. You don't need to pay a lot of money to the lawyers and to the judges. I mean, to the judges as the fees for the considerations. I'm not talking about bribes here. Bribes are much more expensive. If you are talking about the legal procedures in Russia, they are really very cheap. It is hardly, you can hardly imagine the thousands of claims for quite a small amounts of money in the civil procedure in the United States. So, but in Russia you can see a lot of claims for some small, about $1,000 per claim. And naturally, usually even the service for legal service costs more, but still you have a lot of such claims considered by the courts. And that is why mediation service is not so necessary for the people. And also everybody understands that mediation procedure is not a court decision. Court decision is like, you know, equity, paper. It's like a check for some money, so you can come and enforce. But with some mediation procedure, you don't have such enforcement in our legal system. So anyway, the other side can avoid this agreement, and you'll still have to go again to the court to enforce this. So that is why I think that two reasons. So very cheap legislation, I mean courts procedures, and the second is that mediation is not so obligatory as the court decision. These two reasons doesn't help to for the development of the mediation in Russia. Yes, and this is definitely not the question of confidentiality. That's it.
Okay, thank you, Anatoly. Since we have 2 minutes left before going to another stage of this webinar, I was hoping that I could use this opportunity to ask Wim the question. So the question was that since the Netherlands is not only limited to this small country and beautiful country nearby, I was wondering whether you can talk about the administrative law system that are in other parts of the Netherlands, the Kingdom of the Netherlands, and whether the Dutch system has affected this.
Yes, that is, well, thank you. Thank you for this question. The thing is that we have the Dutch Antilles. That's a small group of islands in the Caribbean, and they are formerly part of the Dutch Kingdom. Three of them are municipalities of the Netherlands, which means that Dutch law directly applies there. So we're basically talking of three islands who have a more or less independent status, and in principle they are empowered to have their own laws, but in practice their legislation is in most cases modeled after Dutch law. I don't know exactly the situation for each three of those Caribbean islands, but I think they have all introduced separate statutes, as they're called on administrative law, more or less following the Dutch model.
Okay, thank you very much, Wim, and thank you very much to all of you for your presentations. And we are coming to the closing part of this webinar. So today we discussed two legal systems, the Russian one and the Dutch one. We saw that the Dutch system is much more similar to our system than the American system, although it is still different. In the Dutch system, one can appeal the decision of the governmental authority to a court, and these courts are different, they're separate branch of the power, unlike in the US where the administrative law judges are employed by the agency. We also have learned that the parties in the Netherlands are free to introduce new evidence unless it contradicts the requirements of due process. In this webinar, we also learned that in Russian legal system, the rules for introduction of new evidence is much more strict. The parties are supposed to disclose all the evidence during the administrative process. If they fail to do so, the courts would not really admit the evidence during the trial. In general, I agree with this idea because it seems unfair to me to assess the legality of the decision adopted by the governmental agency if this agency didn't have the chance to actually review the evidence. However, I don't think that this measure alone will suffice, because to me the main reason why people withhold evidence is because they fear that the governmental authority would somehow abuse this evidence. The governmental agencies also tend to request huge amounts of documents, and they make an impression to conduct what is called fishing expeditions with the hope to find something in them. Therefore, I believe that the government has to develop strategies to improve the agency's quality of work and to build public trust in the governmental agencies. And as to a restriction to review interim measures, we can conclude that this restriction, theoretically speaking, can be justified because the governmental agencies have to do their job essentially and not get bogged down in endless court fights. So they have to have these inspections, and they have to be able to do that without going to courts all the time. However, as Denis and Anatoly said, there are some issues, there are some decisions, they are interim decisions, but they just have such a significant impact on the rights of the people that they have to be reviewed by the courts. And then we go to this discussion of what is significant impact. Some can argue that when an agency, a governmental agency, initiates an inspection and it requires so much evidence and documents that it basically blocks a legal department and a bookkeeping department for days, sometimes maybe for weeks. Is it a significant impact? I don't think so, but the whole idea of significant impact is an issue for further discussions. What is certain to me, however, is that administrative justice is important and it has to evolve into being an effective, independent, and trustworthy mechanism. And I hope that these discussions with the review of foreign experience can help to make our system, Russian system, better. So thank you all for being here, for sharing your experience, and I hope to see you in our further discussions. Have a good day, and bye.
Okay.
So I believe
Right.
that we are closing the webinar. Thank you very much.
Thank you.
Thank you.
Thank you.